Hey everybody, welcome to episode 3 of Fairly Legal with Cory and Justin. Great to have you back with us. Cory, how are things going? We're all dressed up today, so that's kind of, at least we're dressed up as far as being dressed up for COVID. So that's an interesting experience to be back in, to actually practicing law again.
It's like trying to tie a tie this morning going, how does this work again?
Today, we're going to go over what we like to call basically an email grab bag. Sometimes we get emails or messages that are posted on our social media accounts to questions that people have for us. And so we're going to go through and answer a couple of them today. So I've got the questions and Cory's going to start with our answers. Well, it'll still be a discussion, but Cory's going to start with our answers. And the first one comes from slip and fall accidents. And the question is, if I get into a slip and fall accident, what kind of evidence should I preserve? Which is a good question. If you get into a fall, if someone, you go to a Albertsons or you go to a store and there's a slip and fall, you go to a casino and you have a fall, you trip over something, you fall over something and you get hurt. The question is, what should I do at that point? Cory,
So
what's the answer to that?
Okay. So every time a lawyer starts talking, you go back to law school and there's like, you're spotting issues in the question and the description of what we're talking about. But there's a distinction that I have to make before we even start, which is this a slip and fall or is it a trip and fall?
It is different. That is a big distinction. Tripping over something versus slipping on something, and there is a big difference.
Because when we talk about a slip and fall, we're probably talking about a foreign substance on the ground. Somebody spilled something, there's some water, there's a leak. Cases that I've handled over the years range from something spilled on the floor that a person walked by and spilled versus an ice machine that was malfunctioning and leaking water onto the ground. It just depends on the circumstances.
And 9 times out of 10, what you're dealing with when you're tripping over something is you're dealing with something that has been there for a long time. It may have been there it may be designed that way to have that, whatever your walking surface may have been designed that way, and you happen to trip over it. Well, a slip tends to be something that, like a foreign substance, something that was placed there and that wasn't there before. And there is a big distinction on what the requirements are for you to establish that anybody did anything wrong in both situations.
Right. So let's divide these up. Let's talk about slip and falls first. So that presupposes that there's a foreign substance on the ground. I mean, arguably it could just be a really slippery surface, but that's a really tough case. Let's talk about something slippery on the ground, water, some liquid that's been spilled there. You're walking along, you don't see it, boom, you fall on the ground. Okay, we get this all the time in our clients' things. If there's video, what inevitably happens is our client will immediately jump up lightning fast because guess what? It's super embarrassing to fall down in a public place.
If you've ever done it and you didn't get hurt, what was your first move? Your first move is to jump right up because it's just really embarrassing. Yeah,
and you look, and my dad always says there's nothing funnier than watching a tall person fall down because it takes us like 20 years to reach the ground. We get to do all before we hit the ground. But regardless, whether you're tall or short, it's super embarrassing. So you jump up and you want to get out of there. You want to get out of the situation.
Even if you've gotten hurt, we've had clients that have gotten actually some pretty significant injuries, but the side of their brain that is embarrassment, that side that's just embarrassed makes them want to I want to just get out of here, even though they've got a pretty serious injury. It's and as Cory, we're going to chat about, there are steps that you have to take that if you don't take them, it could be a real problem. But the first thing you got to get past is that embarrassment, because that embarrassment trigger of your brain wants you to get up and flee and just get out of there.
And so then we get into this preservation of evidence mode because you have to preserve evidence. So, if you were thinking rationally like a lawyer, you would take your phone out and take a couple of pictures of the area, figure out what the substance was, maybe look around, see if there's a witness, ask them how long, did you see this? No one does that. But what you have to do is at least tell somebody, tell a supervisor, a manager, an employee that you see and say, hey, I slipped. Can you come over here? It needs to be documented, because if it's not documented, you walk away and you wait a week to do this. Guess what happens to the video? It may be gone. and there's zero evidence that you fell, no one can document it, and you really have no case. So at a minimum, you've got to tell somebody that this has happened.
And what you really get is it kind of comes across as almost like you're, it's like this is like staged, like you're trying to set things up. But the reality is, if you don't do these things, the insurance carrier and the company that owns that property, they'll absolutely use that against you. You didn't tell anybody, you didn't take any pictures. I mean, it sounds goofy. You're going to sit back and think, well, I mean, my first move, if I'm getting hurt, is to take pictures. The sad reality is the first question they're going to ask is, what did you slip on? And if you don't have a very firm, detailed explanation as to what you slipped on, that's the easiest way to get rid of your case. We don't even know what you slipped on. If I've had clients that have come in and said, well, I just know it was slippery. My foot slipped. I just know it was slippery. That's a very interesting information. And it's very personal to that person. I know they felt that way, but that's not evidence to me. I can't prove anything with that.
Yeah. And it's not like, sometimes you don't know what the substance is, and no one expects you to like put your nose down and, right. You to do that. But you do need to at least establish that there was something on the ground. And interestingly, when you go through a puddle or something, when you slip and you don't see it, you're going to slide through it. You may end up in it, and it may not look like much, let's say water for the sake of argument. It may not look like much water, but your clothes are soaked. And there's a skid mark, a dark skid mark where your shoe went through the puddle. And so, because inevitably they're going to ask you how in a deposition down the road, they're going to say, well, how much water was on the ground? Can you estimate the size of the puddle? And people will be like,
right.
Who knows? How do you
size of a plate, or was it the size?
How much water? And they'll say, oh, they'll take a water bottle and go, maybe about half of this. I mean, it needs to be documented. And hopefully, if you bring an employee over to make a report and do everything else, in that period of time, you've got enough time to think rationally a little bit and go, well, here I am. I better take a couple pictures of my own and document the puddle. Is it going to look bad potentially? Yeah, they're going to probably, so you took a picture of it. But I can explain that away. I would rather explain that away than have zero evidence at the time of trial to show that you actually fell on anything or that there was anything on the ground. Because there's a presumption that if there's water on the ground, not a presumption, the law in Nevada is if there's a foreign substance on the ground, that's negligence. It's not supposed to be there. The question is notice.
Yeah, so you understand. Slip and fall kind of cases can be notoriously some of the most difficult to prove in the state of Nevada. I mean, anyone who's looking at this and is wondering about a case that maybe they have, just so you know, so you go in with the eyes kind of wide open, they are difficult. And the main reason is because the Supreme Court in the state of Nevada has issued a written opinion that basically says that just because you go into somebody's on their property doesn't mean they are guaranteeing your safety. It doesn't mean that they're absolutely ensuring that you're going to come out of that property injury-free. If you have a fall, if you slip on something, that doesn't mean that they're automatically responsible because they own it. They have to know that that dangerous condition is what we call it. They have to either know that it was there, or it has to be there long enough where they should have known and corrected it.
You're going to have to get into, we're going to request videotape, and we're going to look at 30 minutes before and after the accident. We're going to watch this and see if we can figure out, first of all, how the water even got on the floor, how this liquid came to be there. And constructive notice indicates that you knew or should have known, which means you should be inspecting the area. If you have a grocery store, people drop stuff, people spill stuff. In Las Vegas in the summertime, everyone's carrying a water bottle around. You know that. You don't stop somebody coming into the store and say, please, no food or drink. Everyone's got a water bottle. So chances are it's a patron who spilled their own water bottle, or they put something in their cart and it started leaking and they've been dripping around the store. We can't expect the store owner to see that, but because they know that happens all the time, they need to be walking around, inspecting the floors, sweeping up every once in a while to make sure that these things aren't going on. Because inevitably they have that white, linoleum that's, when you put water on it, it becomes an ice skating rink.
Right. And they're not going to tell you how that system works. We've had clients before that have come in and said, well, I asked them for, the information on when somebody went through this, or I've asked them for the video of what happened. Those are in-house corporate systems that are in place, and they're not just going to give that to you. That's not something you get to ever look at or to see unless it's in litigation, unless someone's filed an actual lawsuit. The company's going to hold on to that. So that's one of the reasons why we talk about some of the stuff that you're going to have to do or that you could do. It seems like, wow, I mean, it just seems like I've set this whole thing up if I'm sitting there taking pictures. But the reality is, if you don't take those pictures, you're not going to see that anybody else has them unless you file a lawsuit. No one's turning that over to you because they're going to consider that corporate. That's going to be in-house, company stuff.
You'll never get it. And they'll make you, they want to get all kinds of information from you. They want you to fill out an incident report. They want you to describe exactly what happened. They want to look at your shoes, which is fascinating to me. They always want to talk about the client's shoes.
We tell all the time, people like everyone, because you have to preserve your shoes, keep a hold of those shoes that you slipped and fell in it. And it's the goofiest thing in the world.
Yeah, no, and it doesn't matter. At the end of the day, they never make any headway with it, because at trial, they'll say, oh, and what kind of shoes are we wearing? Flip-flops. And then we put their witness on the stand and we'll say, do you have a no flip-flop policy in your store? Well, no. So you don't tell people don't wear flip-flops to your store? Well, no. Okay. So basically we're done with that issue then.
Well, and the most absurd, the most absurd kind of example of this is go to a casino. We've had clients that have had slip and falls at nightclubs, and they're wearing high heels. The ladies are wearing high heels when they go in. And the first thing that the defense wants to talk about is what kind of shoes you're wearing. You're wearing high heels. Why are you wearing high heels? Well, then it turns out that the policy of the nightclub is that a woman can't come into the nightclub unless she's wearing heels. You can't come into that club if you're wearing flip-flops. You can't come into that club if you're wearing some form of comfortable shoe. Yeah. No, you can't come in. But their first question to you is, you're wearing high heels. This is your fault. Yeah. Even though it's their policy that you have to wear those heels. We see it all the time.
Yeah, and they will attack you for the shoes. Keep them. I guess it's good for somebody to look at, but it really makes no difference to the case. But they will make you think that somehow you're responsible because they go, "Oh, flip-flops, huh? This is on you."
Right.
It's not.
The most important thing you can do is contact somebody for the property where you're at and let them know that it happened. The number one thing that we get is the first thing that is the most difficult of a case is when somebody comes to us and tells us about a slip and fall, and they got up and left, and they came to us, whether it's a day, a month later, a week later, but what they never did was talk to the company where they fell because they were embarrassed and they just got out of there. Or maybe they came back to there a couple of days later. Those are tough. You need to let somebody know that it's happened there at that moment so that the company does have the ability to do an investigation. Whether we like it or not, like their investigation, at least it gets done.
Right. And it's understandable if you leave without reporting it, because maybe you think nothing's wrong and you wake up the next morning and you go, oh, wow, that's not good. You go to the ER and you realize you've got a fracture, or you've got, some issue with your knee and it's swollen up and you didn't realize it at the time. It happens, but it's a much, much more difficult case. And we were talking about the substance that's on the ground and determining how long it had been there. There's one situation where that doesn't matter. If an employee of the store or the business actually spills that, whether it was on purpose or not, if they caused the spill, the company is deemed to have actual notice, and that takes away all of the requirements. Basically, that makes our lives so much easier, because then the case just comes about your damages, because you basically put a foreign substance on the floor, whether intentionally or negligently. You put it there and somebody slipped on it. A foreign substance on the ground is inconsistent with the standard of care in Nevada. Ergo, you own the slip and fall. Those are rare, but they do happen. Regardless, so we need video, and most businesses today will have video. It'll show not just the what was on the ground, but it also show the fall, because sometimes a jury can hear about a fall and they're underwhelmed, but you show them a video where somebody falls back really hard, they hit their head on the ground, and the jury goes, oh, okay, there's something there. So it can actually be helpful from a damages perspective as well. Well,
it ensures to a great degree that they're going to hold on to that video. If the company doesn't know that you've had a fall or that there's a claim being made, you just understand nobody takes video and holds on to it for a year. They're recycling CDs, they're recycling DVDs, they're recycling, I mean, for years, there's still some companies, I'm gonna be honest with you, I think they still recycle tapes. I mean, it's some of these systems do not get updated. They're out there for years.
And it cracks me up, that show. Remember that show on TV called Vegas?
Vegas, like it was like Las Vegas.
Yeah, something like that. Anyway, they'll go back in the security department. James Caan was in it, and what's the other guy's? Anyway, I can't remember. But they go back in the security department, and they would have facial recognition software and all this state-of-the-art equipment. And I actually, back in that time frame, I represented a lot of hotels. I was doing defense work, and I would go back in the security rooms, and it was literally a grainy VHS tape that they're showing me. And I'm going, yeah, I think there's something there. You know, but jurors have this idea that the casinos are so sophisticated. And you know what? Over the gaming tables, that can be true. They are fairly sophisticated because of gaming control board about what they need to do and how they can show what's happening.
It's where the money is.
Yeah.
When they have to worry about money.
Yeah. They're going to be all over it. If it's just a public area of the hotel, around a restaurant or a walkway, they're not going to, you're lucky if you can find anything.
I mean, we both represented hotel casinos years ago. We've done that work as far as we did that work over a decade ago. Yeah. And now since we've begun on this side of the table and actually started suing those companies, nothing's changed. Nothing's changed. I mean, those systems that are in place were expensive when they first installed them. And then their position is, hey, they work. So we're not spending a bunch of money to upgrade this. And so, yeah, like Cory said, those TV shows that show like they've got millions of dollars worth of video equipment in there, that's money on the books that they are never going to spend. Yeah, no way. No way. Not when it comes to like an entrance to a hotel. So yeah, when it comes to documenting this, just making sure that they have it, because you'll be shocked at how many times we watch a video out of any one of the main casinos here in town, any of the resorts, any of the grocery stores, Smith's, Albertsons, and the video looks like something from 1965. It's super grainy. It doesn't show nearly as much as they think it does, or maybe sometimes it doesn't show as much detail as I would want, but at least it's something. And we'll never know until we see it. So when you tell somebody that it's happened, it puts them on notice that they have to save that tape, to save that detail so that we can at least check later and see what we got.
Right. And we won't know, like Justin was talking about, we won't know really how good your case is. We're going to have to just kind of have a gut feeling that this is a case we can pursue, because we won't have the incident report. We won't have the video until after we file the lawsuit and do our initial exchange of documents. So none of that will be coming to us. They're never going to show us the video beforehand. They just don't, unless it's an absolute staged thing where it's a fraud. And
I've never had it.
I've never had it, but I've had people tell me that before. I'm like, okay, great, send me the video. I'll drop this case. I don't want to pursue this.
Right.
And I never get the video. But
yeah, and so it's clear. I mean, if you go out and hire an attorney, the attorney's not going to get that information either, not unless a lawsuit's filed. Their position is that's company property, and the only way they got to produce it is if they get sued.
Yeah.
And so that's how we get that information. But in the interim, before a lawsuit ever gets filed, that's one of the reasons why I like it if a client has the ability. Now, part of this comes with the ability, because we've had clients that have had falls where they fractured their femur or they fractured their shoulder. They're in so much pain, they're not taking photos. It's just not going to happen. And that's okay. Don't try to take photos at the expense of like your health. But if you can, great. If you can take them, fantastic. Let's get them taken. If you sit back and said, you know what, I'm one of those people who got up and left, or would get up and leave, and then I find out later that I am sore and I'm hurting really bad, and it was way worse than I thought, just go back. Go back and let them know what's going on. That's not ideal, but at least it's something. It's better than waiting too long. Don't wait to see how bad it really is before you go let them know. Putting them on notice. I had a client once before who slipped and fell on a water area at a drinking fountain located inside of a grocery store here in town. But her car was also in for an oil change. So when she slipped and fell, she was trying to get back. She was embarrassed, so she was getting out of there. thankfully, I mean, she had water, her pants were wet, so there was no dispute that she had slipped and fell in it. But she went back and she was able to come back a little bit later and put them on notice. Now, that case was still difficult just because of that gap in time. That gap in time still caused me grief as the lawyer, but at least it was done, and the defense could only get so much mileage out of it. So putting somebody on notice is very important. That is step number one of preserving anything after a fall.
Yeah, because we have to, if you put them on notice, even if you don't retain a lawyer, but you put the company on notice, they're on notice. They know that there's a potential claim. They need to preserve the video. If they do an incident report, especially like grocery stores, national chains, they'll have a list of like procedures to follow after a slip and fall. So, it says, take a picture of the area, preserve the video, get an incident report. They do all these things. They'll, they always say, take a picture of the person's shoes, which I don't know. But again, that'll be, it's on their sheet. I'm telling you, it's on their sheet every time.
It is. You will absolutely have someone take a picture of your shoes.
So because they have a procedure in place, if that video disappears or the incident report disappears, then all of a sudden the company looks bad. It looks like they're hiding something. There's laws and case law about preservation of evidence, and that can put your case in a posture that we might be able to resolve it just because the lack of evidence that they should have kept that they didn't. So that can work to your advantage too.
The other big thing that you should do is, if anybody who's a patron of where you're at, the store, casino, wherever you might be, whoever's a patron that maybe have assisted you, maybe they helped you up, get their contact information, see if they saw anything. If you can have a witness that supports you, maybe they look down and just identify what it is that you slipped on. Even if you don't have time to take a photo, if they can identify it, oh yeah, here's what you slipped on, and then get their information as a witness, that's a big deal. So many times cases really come down to the person who fell and the company that is in charge of the space. And the reason is because no one wanted to bother. No one, I mean, there are other witnesses that may have been there, but no one, I don't want to get involved. And so if you don't ask them, they're just going to say, are you okay? Let me get you some help. And then they're going to go about their day. They're going to leave. And then once they leave, you're never going to find them again. So finding a witness if they're available and getting their contact information, you don't have to, interview them in detail. But if you just get their contact information, if you point out what you slipped on and get their name and phone number, that can go a long way in helping resolve your claim.
Yeah. Because the arguments that you'll get are insane. I have one right now. And you have another case that's similar to this, where security or the adjuster will look at this video and say, aha, that's where it happened. I have a case where they claim that the patron who walked in right in front of my client spilled the water. I've watched the video 100 times. I don't see that lady carrying anything. I don't see her spilling anything, but they've convinced themselves that this woman that walked in front of my client, like 5 seconds before my client, spilled water on the ground. And because that's what the best case scenario for them, there's clear water on the ground. It's documented that there's something on the ground. So they have to show that it was just barely there. There's nothing they could have done about it. And that's the best case scenario. It's like I had a case, shoe case in your, yeah.
I've had a case where,
or the purse. No, there was a purse.
Yeah. My client was walking out of a store, and the surveillance wrote in their surveillance report that she fell because her purse got caught on the door handle and spun her around and knocked her down. We watched that video. I watched that video 100 times. I even watched that video with the attorney for the defendant, the defense counsel, and both of us looking at each other, shaking each other's heads going, this guy is in dreamland. He's just made this up. This video doesn't show even remotely that. Even defense counsel recognized that. But they wrote it. I mean, that was literally written in the report from the surveillance footage by the surveillance officer, that's what he saw.
Yeah.
And so if we had just gone off what the report said, everyone would have said, oh, she didn't trip on anything. She just got her purse caught. But when we actually watched the video, it didn't even remotely look like that. No one saw it that way. No. And so there are a lot of things that people will argue. For us, the most important thing is being able to put our case together. I had another case where a person had got their hand injured in a case, and the claim was that the dangerous condition was created by a patron who ran into this thing, who ran into basically an end cap at a grocery store, and they're the ones who basically created this dangerous condition. When I actually took the deposition of the manager of the store, his position was, that's not possible. Even though that had been the story that I had received from defense counsel, from corporate, from the insurance adjuster, when I actually took the manager's deposition, he said, it's not possible. That piece that they're saying he ran into is over 300 pounds. Him running into it wouldn't have moved it an inch. It wouldn't have done anything with that thing. And so the idea of people will say all kinds of things. And we have heard 1,000 different defenses. Some sound really good. Other ones are just absolutely terrible. For us, it is, what can you do to put your case in the best light for yourself and for us, or for any attorney who may be handling a case like this? Because you're going to get a lot of roadblocks in your way. They're going to mount a defense. No matter how much you think this was so outrageous of them that caused you to fall, they're going to mount a defense. The best thing you could do is, how do you protect yourself from whatever that defense is going to be?
You know, and Justin, you said earlier that, you know, it's not automatic. Just because you fall on somebody's property doesn't mean they're liable. That's not enough. The burden of proof is actually fairly high, and it's pretty difficult. So they can be tough cases. So let me tell you a little bit of the reality of how a lawyer looks at a case, a slip and fall case. If you have just some bumps and bruises and you go to a few physical therapy visits and you go to an ER visit or an urgent care visit, and that's it, it's going to be tough to get an attorney to take your case, because at the end of the day, these cases are going to be expert driven, and to get an expert to look at the case and evaluate it is extremely expensive. The lawyer's going to have to lay that money out and to get the expert to review it. And if the scale of the case doesn't warrant that, you just have to go, I can't do that. We can't risk this for such a small case. If your medical bills are like $3,000, you're going to be hard pressed to find a lawyer. That's just the reality, just because of the scope of the discovery that's going to be done and things we're going to have to put on. We're never going to be able to take the case.
And honestly, if you have bumps and bruises, maybe you rolled your ankle and it's sore for a few days. The best advice I can give you is, if you're going to contact them and just see if they'll help you out with your medical bills. I mean, that's it, because that's all that anyone is going to do. If you aren't hurt that bad, you're going to have a really difficult time finding an attorney, in part because when I said before that they're going to mount a defense, they are. Yeah. They will. I have settled a slip and fall case prior to filing a lawsuit maybe twice in 20 years.
Yeah.
In 20 years of doing this, maybe twice. Every other time I've had to file a lawsuit. And some of those cases factually were pretty outrageous in my opinion. I thought for sure I would settle them. There I was having to file a lawsuit, because they will always mount the defense that they didn't know. That they unless you got them, their employee created the condition, their number one defense is, we didn't know. For all we know, it had been there for 5 minutes before you got there. And so all of a sudden you're in a lawsuit. And you could have, like, I literally broke my hip. I had to have a surgery on my hip. I had to have a surgery on my shoulder, and they're going, yeah, but we didn't know about it. And so the next thing you know, you're filing a lawsuit.
Yeah.
So understand, litigation is almost guaranteed if you fell on somebody's property and got hurt. So if you got hurt and the hurt isn't that bad, it's just kind of like, well, I rolled my ankle, some bumps and bruises. But if you need a doctor, a lot of places have a medical payments coverage policy where they will provide some medical benefits to someone who's been injured. It's not a huge policy, but they'll provide some. Sometimes they will help out with medical bills. You can try to go down that road, but just don't keep your hopes up. Don't feel like, well, if they don't treat me right, if they don't take care of this, I'm going to go talk to a lawyer. Because I'll tell you now, if you're not hurt that bad, the lawyer's going to go, man, that stinks. I feel bad for you, but there's not a whole lot I can do.
Yeah, I mean, and it's great to have a partner, because then you can go, my partner would kill me if I took this case. Because I'm either going to maybe break even on the case, or
and you're going to only break even. You're going to be, I mean, the person who's been injured you're not going to have the outcome you think you're going to have.
Yeah. And then you're going to hate me because I didn't do a good job for you. And I never should have taken the case to begin with. Like I took one, and you reminded me of this. I took a case for somebody who's kind of a friend, and I'm worried about it. But luckily, this business had a $10,000 medical payment policy.
Yeah.
So we were able to get all of her medical bills paid basically, or get her reimbursed through her insurance. So at a minimum, we break even. I can, with some level of confidence, go in and say, well, let me see what you got. Show me your cards. And then we can decide if we want to, go the distance with it. But yeah, those medical and a lot of businesses do carry those medical payments policies where they don't care about fault. If you get injured on the property, they will pay out a certain amount. And all you have to do is establish that you actually received the care, send them the bills, the records, and off to the races.
Okay. So we hope that you take this to heart when it comes to the things that you do. You make sure that you notify somebody that you've been injured. Take photos of the area that you slipped and fell if you can, if you're able. If you got your phone, take pictures if you're able, and find out if you have any witnesses that may have seen it who may be able to support what you're saying about what you slipped on. Sometimes it's obvious, sometimes it isn't. So as long as you get those things and you square that away before you leave, you're already ahead of the game as far as showing up to an attorney's office if that becomes necessary, if you've hurt that bad. If you get injured in a way that's really serious and you can't do that, if there's anybody around you, if you came with a husband or a wife, you came with one of your kids, you came with somebody else, ask them to take pictures if they're able. Take pictures if they're able before you're taken out. Pictures can be a huge thing for us, especially if you don't know what you slipped on. Most people, especially people who get hurt really bad, a lot of times don't know what they slipped on because you're so focused. It happens so fast, and you're so focused on your pain from the severity of the injury, you don't even know what happened. It happened that quick. And so sometimes if there's somebody with you, just ask them to get pictures. If you're able. I mean, a lot of these things come down to what you're capable of doing. But I've had clients that, when we ask them and they were injured badly, what happened? The person who actually got injured had no answers for me because they got hurt so bad that all they thought about was their pain. It was their significant other, their spouse, their boyfriend, girlfriend, wife, whatever. That person is the one who's now coming and giving me actual details on what happened because they didn't get hurt. They were able to see it.
Yeah. And slip and fall, just like any other case, don't delay medical treatment. And especially in a slip and fall case, if you wait more than 1 or 2 days to go to a doctor, you probably don't have a slip and fall case. You're probably not injured bad enough to pursue this through, a legal, through, getting a lawyer and filing a lawsuit or making a claim. You need to have some fairly significant injuries. And if you don't go to a doctor for a couple of days, that makes your case even harder because you don't document it and you never went to the doctor. How do we prove this even happened? And they will say, you're making this up, and they assume everyone lies.
The only add-on to that then becomes trip and falls. So we have the slip and falls. Now, trip and falls tend to be things where you tripped over something that already was there and sometimes was just built that way. Or maybe somebody put something in place and you just trip over the top of it. Now, those kinds of cases does not mean that you can't recover, because then the question becomes, why was it there? I mean, what happened? I've had cases before where somebody they were in a parking lot and there was a handicap. If you've ever go to a parking stall and you have the handicap post that's coming out, well, they were removing those. And so they cut off part of the handicap sign, the metal handicap sign, but they left a stub that was about that high in the asphalt. So in the asphalt, they have this stub that's about 4 inches tall. I have no idea why they left this stub there, but here's a woman who's coming out of the store and it's nighttime. She has no idea that the stub is still in the parking lot stall area. She trips on it, boom, she goes down. That is by itself, the argument is that was negligent. Leaving the stub, even though it's something that is designed, it's more permanent being there, as opposed to just this dangerous condition that got created later. Here you have this condition that it's there. I mean, it could have been there for years. I have no idea when they cut that thing down. But those are conditions where she tripped, falls, we have a claim. So just because you trip and fall, and maybe you trip and fall on something, you're like, oh man, I feel like maybe I should have seen this, or maybe I didn't, it's something that's been there for a while. It doesn't mean you don't have a claim, just so we understand that.
Yeah. And it may not be obvious. I had a great case that I settled for a woman against a casino. She was parked in a handicapped area, and I call it my crosswalk to nowhere case, because she walked out of the casino, walked through the crosswalk as she should have, got to the end of the crosswalk, and it didn't take her anywhere. Her car was, had to walk through the bushes on the other side of a little landscaped island. And that's what they done. And this is someone who's parked in the handicapped parking. She was elderly. And so she either walks back out into traffic, or she maneuvers through this thing, and she trips on some of the bushes there. They've just made a trail that they've clearly forced other people to walk through here before, because there's a trail through the landscaping, and she fell, not surprisingly, and was seriously injured. On its face, it didn't look like anything. I mean, there was a crosswalk, there's handicap parking, and they looked like they'd done everything right. But when you really look at it, you realize, hey, wait a minute, there's more to this here. And that's another thing. Like there are codes. Like if it's a stair, the stair rise and run may be off. There may not be a handrail. So there are other things to look at in a trip and fall that you don't have in a slip and fall. You're more looking at just this condition. And that can be a lot of different factors. They can be easier in some ways and harder in some ways.
Yeah. So you're clear. When we talk about that, we're talking about building code requirements. That when you're dealing with trip and falls, the building code tends to come up, because we're starting to look at whether or not whatever this thing we're looking at is up to the requirements, the building code that is required. So those are all things that still come into play. Now, as far as preserving evidence, not much changes. Just because you tripped over something is really what we're dealing with as far as the mechanism of what caused you to fall. But the process of what you're going to do to preserve evidence, that's not really going to change. You still need to notify someone that you fell. Sometimes you're going to be falling outside of their property in a parking lot, because that's what we're going to be dealing with. Still go in and tell them. They may sit back and say, we're not responsible for the parking lot. I totally get it. It doesn't matter. Notify somebody. Make sure you document that to somebody in that area who's a business owner who can document that you had your incident. Secondly, again, we got photographs, witnesses if you're available. Getting all the same stuff really is still just as important. Photographs, though, become even more important in a case like this, because now we got to see what it is that we're talking about. Where is the area? So that we can go back and look at it. Because sometimes you may be going into a space where there is no video footage anymore. Right. And so now we need to be able to see what it is that caused you to trip. And
you do need to preserve evidence, but the urgency requirement really isn't always there. For example, they're not going to just tear out a stairway, the day after you're slipping, you trip over the stairs. You're probably going to have a few days to go back and take pictures. You may have years to do that.
Unless, of course, you don't tell anybody, as Cory discovered in a case that he had.
So you never really know. But hopefully, if you report that, and once you come to us, one of the first things we're going to do in a premises liability case is we send out a preservation of evidence letter. We say, hey, by the way, they're represented. This is what generally had happened. If you make any changes to this, you need to advise us so we have an opportunity to inspect it with an expert before you remove it, alter it, change it.
And what happens if the person doesn't tell the company that they've had their trip and fall?
Yeah, then
Cory literally had a case where someone had a fall, and they had a fall on a staircase that was set to be redesigned. They'd already planned on doing a redesign on that staircase. But she didn't tell anybody about her fall. She didn't tell anyone about it. And she had some pretty serious injuries, but she didn't tell anyone. So by the time Cory gets involved, that whole area, everything's been changed.
So we're looking at photographs trying to go, well, let's measure this and try to put it to scale. Super hard to do. And
you can't really go after the company for making the change, because they were totally unaware that they even had an issue.
Yeah, no idea. And it hurt me too, because there would have been video. There would have been video that I could have used to demonstrate her damages, because they were even critical of her damages. So the video helps me. It doesn't hurt me. And it may be bad, and ultimately we may have to settle for less than we want, or maybe it completely destroys the case. From time to time that happens. We get a video and we're like, look, jury, we can say what we want to a jury, but they disregard what the lawyers say. They're going to look at the video and make their mind up about what what happened. So that video can
that
kill you sometimes too.
It can, but even if that video is not helpful to you, at least you have the information to know that, hey, it wasn't as bad as you thought. Maybe in your mind, the slip and fall or the condition was far worse than what really actually happened. And the video shows that.
Yeah.
Maybe it's a very arguable thing. A lot can happen. The number one thing is we won't know until we've seen it. And if you don't tell anybody, you run the risk of a change being made. And then all of a sudden you can't do anything about it, because now I can't attack a defendant for destroying evidence that they didn't know that they had to maintain, because they didn't even know anything had happened. So you have to let somebody know what's happened to you. Those rules about slip and falls are the same for trips. You have to let somebody know what's happened so that they can document it and that area can be protected. We can send somebody out to check whether or not there's a building code violation, whether there's some issue going on that they didn't take care of. Can't do that if that's all been changed because they didn't know they had to preserve it.
Yeah. And maybe it doesn't violate the code, but maybe it's just a bad idea, just a bad design, a dangerous issue. Or maybe it's something that originally when it was built, it's fine, but now all of a sudden there's a gap between the joints and the cement, and it's, 3/4 of an inch high. Well, that's too high. That's an unsafe condition.
Yeah. For example, I've had a case where someone had steps. The steps had been there since the 80s. And what happened was at the bottom step, they resurfaced the parking lot. And when they did that, they raised the parking lot asphalt so that the very bottom step was actually only about this high now on what used to be a normal staircase. Well, they didn't color it. They didn't put yellow on it. It's just this tiny little nub that's about this high on this staircase. So when people are actually going up and on it at night, they have no idea that there's still a step. So we had a client that stubbed their foot right on that little edge, go down and just did a face plant right in concrete steps. Now, when those stairs were built, they were totally up to code. The problem is there was a change and then no one corrected that bottom step. They just kind of moved on. That became an issue. And so, understand, just because something may have been up to code at one point doesn't mean that changes don't get made that all of a sudden make it dangerous.
Yeah. And, there's always the hybrid between where the step versus the water. It can also be like, I've seen the vacuum cord case where the housekeeper has stretched the vacuum cord out right across the hallway, and it's flat, and then all of a sudden she pulls it and she trips you. Those are rare, the same thing, and those are really hard to document because then she pulls the cord up, walks away, and how do you?
The employee's trying to get out of there.
Yeah. So that's when you really need video. If you don't find video on that one, you're out of luck. But and then I can't believe we didn't really talk about this, but one of the main defenses to this is always, well, why didn't you watch where you're going?
Right.
Where were your eyes? Were you looking down when this, as you were walking? Well, guess what? Nobody looks down. When you're driving a car, you don't look at the road, 3 feet in front of you going, you're looking way off in the distance to try and, maneuver so you don't hit people, cars, and we do the same thing when we walk, but they will always attack you. Well, where were you looking? Well, where you were looking? You were looking to try and find the cereal that your kid wants, as you're walking through the aisles of a grocery store. You're not looking at your feet. You're looking at all the products that they've displayed in such a way to draw your attention to them so that you'll buy that product or buy the thing on the end cap. But they will fault you for not basically having your head down, watching your feet the entire time.
Oh yeah. And they'll fault you for just about anything.
Yeah, pretty much.
So just be mindful of that. That's why I say, and Cory and I kind of put this together as far as questions for what you preserve, because I can anticipate their defense. Cory and I can anticipate whatever the defense is going to be. I can anticipate it, but we have to be able to have certain pieces of information and evidence to be able to overcome the defenses that we anticipate happening. And that's one of the main reasons why we wanted to give this, address this issue in our podcast, is so that you have that information at hand where you can say, okay, this is the steps that I need to take should anything ever happen like that, because those are the ways you're going to overcome it. And sometimes what we're dealing with is a very, very serious injury. I mean, a life-altering or debilitating injury. And if you haven't done these steps, it can be devastating, because then it's very difficult to recover anything on something that can be life-altering.
Yeah. And as always, don't decide for yourself if you have a good case or not. Talk to a lawyer. I'm happy to talk to anybody about a slip and fall, trip and fall case. If for no other reason, like Justin said, just to put your mind at ease that, hey, it doesn't look like anybody really did anything wrong. This is just one of those unfortunate things that happens. But sometimes somebody will tell me a thing and they're looking at the wrong thing. They're looking over here and I'm like, whoa, what about this over here? This is the real issue. And they're like, oh, I didn't think about that. So we can find the issue. We can spot the problem that maybe you don't even know exists. But the more information we have, the better we can help you. And if you preserve that, we might be able to find a case. You may have something that you didn't realize you had.
It's true. So we hope this helps. If you have any questions, or if you have a case that you've got questions about, maybe something that's happened to you, always feel free to give us a call. Like Cory and I said, we're always happy to talk to people, go over kind of facts with them and just kind of let them know what our thoughts are and what we think that they can do. So if you're in that situation, just feel free to give us a call. But other than that, we hope that this information helps you going forward. Make sure that you document that should anything ever happen to you or anyone that you know in the future.
That's it.
Thanks everybody. Have a good one. Thanks.